Coca Cola has never patented its formula, not in 135 years. And that single decision is conservatively worth tens of billions of dollars. Meanwhile, thousands of startup companies pour tens of thousands of dollars into filing patent applications every year on things that they may or should have kept secret. Or worse, they keep inventions secret that they really should have filed patents on. So how do you know which path to go down? Today we're going to go through the top 5 questions that could save your business millions. Patents or trade secrets? Here's some quick context so that we're on the same page. A patent is a limited monopoly granted by the government. In return for your disclosing your invention to the government, you get the limited ability to stop others from making, using, selling, and offering for sale your patented invention. A trade secret is very much the opposite of a patent. A trade secret covers anything like an invention, know-how, processes, client lists, anything that you keep secret that gives your business a competitive advantage. However, the way you protect your trade secrets are with things like NDAs, access controls, trade secret policies. But the moment a trade secret becomes public, it's no longer a trade secret. These are two very different philosophies, but they're meant to do the same thing: protect your intellectual property. If a competitor bought your product today, could they take it apart and figure out what the secret sauce is, how the invention works, how it operates? If the answer to that question is yes, then keeping that secret sauce, keeping that invention a trade secret, is likely useless, because trade secret protection doesn't prevent your competitors from reverse engineering your inventions. A patent is what stops reverse engineering from occurring. But if your invention is a process, if it's something that if I bought the product, it'd be very difficult to figure out what the secret sauce is or how the invention actually works, then that's something that you may want to keep a trade secret. This is the Coca Cola situation. You can't taste the formula. Utility patents last 20 years, design patents last 15 years. But it takes a good amount of time to get those patents. Trade secrets, on the other hand, can last forever. But there is no registration phase for getting a trade secret. So as long as you're keeping that trade secret, you've got trade secret protection. That being said, it takes at least 2 to 3 years to get a patent application issued by the US Patent and Trademark Office. So if you've got a technology, if you've got a secret sauce, if you have an invention where the shelf life, the usefulness, the viability in the market is very limited in time, with 2 to 3 years, it might not make sense to spend your time and treasure on getting a patent, because the patent will issue after the technology is obsolete or is just not useful anymore. On the flip side, if you've got a product that's got a much longer shelf life, if you know that this is going to be the next gen product for the next 2 decades, well then a patent becomes very attractive. Can you actually keep it secret? Now, this question is about being brutally honest with yourself and your company. Trade secrets only work, they're only enforceable if you're able to keep them secret. If you're able to have things like access controls, NDAs, employee agreements, confidentiality agreements, doing exit interviews, having an actual HR policy and document tracking. Things like that to make sure that the trade secret stays secret. In some jurisdictions, if you can't actually prove that you used reasonable measures to protect your trade secret, well, you lose trade secret protection, even if someone obviously stole it. So for instance, if you're a 3-person startup with a Google Drive, no real policies at all involving trade secrets, you probably won't be able to maintain a trade secret, so you may want to go down the patent route. That being said, a 200-person company with a compliance team, with a legal team, with actual HR policies, now a trade secret becomes more viable. So be honest with yourself here. A failed trade secret is worse than no protection at all, because now your invention is in the public and it's unpatented. Will you actually enforce it? This one is underrated. Patents and trade secrets have very different enforcement profiles. With a patent, you can see the infringement. A competitor launches a product, you buy it, you compare it to your claims, and you'll know right away whether or not it matches your claims. It's visible, it's provable, it's expensive, but it's doable. With a trade secret, you don't find out that a competitor stole your product until they start selling one. And you have suspicions as well that an employee maybe told them about it. Proving they got it from you and didn't independently invent it themselves, or they didn't reverse engineer it, is much more difficult than proving patent infringement. You'll need things like forensic evidence, a paper trail, often an employee who ends up jumping ship to the competitor. If your market is full of well-resourced competitors who absolutely try to copy you, patents give you a stronger, clearer leverage. If the risk are your employees walking out the door with the knowledge they learned while working for you, trade secret law plus strong contracts may be the route for you. What's the cost of disclosure? A patent is a public document. Anybody in the entire world can pick it up, read it, figure out what it does and how it works and how to put it together. This includes in countries you don't have patents in or you can't enforce it in. For some inventions, that's fine. For others, it's actually a gift for your competitors. You're handing them the blueprint to how to compete with you in the marketplace or how to design around your patent claims. Ask yourself this: if a competitor picked up your patent today, built the product that's in the patent, sold it in other jurisdictions around the world that you can't enforce your patent in, do you care? If the answer is yes, the patent might actually accelerate the copying you are trying to prevent. Trade secret becomes the smarter move in that case. That's why things like advanced manufacturing, chemical compounds, AI training models are kept as trade secrets because the cost of disclosure is just too high. The key to protecting your IP is being intentional and proactive. These 5 questions will help you do just that. Thanks for watching. Catch you next time.